You're entering the voting booth. I'm John Fortier of AEI.
And I'm Don Palmer, the Election Assistance Commission.
And this is a podcast about the inner workings of elections. A little bit of explanation. We have a guest today, Ned Foley of Ohio State Law School. We'll introduce him more properly in a minute. But we are having a podcast here with a live audience and lots of ways to watch it. We'll be hearing from you, or you'll hear from us in the regular podcast mode shortly. We also have C-SPAN here, so some of you may be viewing us from afar. And we also have an American Enterprise Institute live feed. And on that feed, we actually will be taking some questions. Those questions may not make it all into the podcast, be part of this event, but you'll still be able to ask that either in the room or there. And just to give you the logistics, the way to ask a question online is to email Jaehun Lee, that's JAEHUN.LEE@AEI.org, or on Twitter or X to use the hashtag AEI voting booth. So we hope you'll submit your questions. We'll have some time for that at the end. With us today is Ned Foley, who is a professor of law at Ohio State University. You've heard him on our podcast before. We discussed the Trump v. Anderson case earlier in the year. Ned is one of our leading experts on election law, and that means current election law, issues that we talked about today. But Ned has also been the author of a book, and now with a new edition of a book called Ballot Battles, the history of disputed elections in the United States. And this truly is a very important scholarly work, as well as very important for today's world, looking at many of the disputed elections that have really come since our founding, the idea of disputed elections, how we resolve them. And this book had some great impact, and I learned a lot from it back when the first edition came out in 2015. But as you can imagine, we've had some other things happen since then, and we have really more to talk about. And Ned has put out an updated edition, which is just out, just available for Labor Day gifts, going back to school gifts, I don't know, early Thanksgiving gifts, Christmas gifts, not too early ever to get this book. I highly recommend it. And we're going to have an opportunity to talk with Ned about this today. So Ned Foley, welcome to the voting booth.
Thanks so much for having me. It's great to be here.
Ned, welcome. Thank you for being here today. Let's talk a little bit about the broad theme of ballot battles and how we should and how have we sort of treated and resolved disputed elections. And there's been a number of these. It's a very historic book. Let's talk a little bit, maybe start with John Jay's 1792 governor's election to illustrate where there was real concern about the legitimacy of the election. And some concern about that. Let's talk about the book and that particular race.
Sure. One of the fun things about doing the research for this book was discovering all these things about American history that I had never known before. I had heard of John Jay, one of the founders, authors of the Federalist Papers, but I had no idea he had been involved in a dispute. And that particular dispute is really the first big one that we've had in our history. And all of the themes of subsequent disputes are there at the beginning. And so you can see the founders wrestling with this problem. And the interesting thing from my perspective is they didn't have a good solution to it. They were working through it on the fly as they were going through. It wasn't like they had all the answers ahead of time. And so you see James Madison writing letters to Thomas Jefferson and back and forth. And Alexander Hamilton is operating kind of as the campaign manager for John Jay's effort to become governor of New York. And the other thing that didn't occur to me until I studied this was being the governor of New York was more important than being the Chief Justice of the United States at the time. John Jay was the incumbent Chief Justice, and he was willing to give up that job to be governor of New York. We wouldn't think of that trade today, but federalism being what it was, the states being important, being the governor of New York was a really big deal. And the particular details of the dispute we could discuss, they're not important. What's important is both sides had a plausible claim to the validity of the disputed ballots. And the ballots in dispute were from Cooperstown, New York. If any of you are baseball fans, there was no Baseball Hall of Fame back then, but it was that town. And there was some ugly things going on in that town. People are accusing the local leaders of partisanship. And again, the founders didn't want political parties, right? They write the Federalist Papers to hope that they can have checks and balances and separation of powers so we can keep factions at bay and not form parties. But 1792 is the beginning of political parties being created in the United States in earnest, both at the national level between Madison on the one hand and Hamilton on the other, and then it's playing out in New York politics as well. And so partisanship takes over the dispute. And there's a particular institution that's set up by the legislature to determine the outcome, and one side accuses the other of rigging, if you will, that term, the tribunal to decide the case as imbalanced to one party instead of the other. I can go on, it gets very ugly. It almost becomes a little civil war within the state of New York. Local militias are getting involved, some shots are fired. Thankfully, no one was killed, but it's an example of very at the beginning of our country, we're not so well equipped to handle it, and it's because it's a governor's race. And gubernatorial elections are a new thing for this young country, and we could talk about that more if it makes sense.
If I could follow up, Ned and I have known each other since not too long after Bush v. Gore, and we've been talking about these issues in various ways over the years, and I will say we probably had a little bit of a dispute. We agree on a lot of things. One of them that we disagree on typically is, I think, Ned, at the end of the day, you hope that when we get to the final stage of resolving an election, that a sort of neutral arbiter will decide that, whether it's a judge or a panel or some ways. And I guess I'm probably a little more comfortable with parts of the political process being there at that final arbiter stage. That probably makes you a more fair person than I do, but I appreciate all of your work. The book, in some ways, I don't want to say it's an argument against my position, but it is an argument to show that. So one, talk a little bit about that, but I guess I want to put it in two ways. You mentioned this governor's election that was different. One of the things that's different about elections, especially at the beginning, but still persists today, is that legislatures determine the outcome of their own elections. They were the final arbiters. So the House of Representatives today still is the final arbiter of a dispute over a House election. The state legislatures, the same thing in the states, they always were. And at the beginning, we had mostly state legislative elections, but we had these governor's races were a little different. So can you talk a little bit about the neutral arbiter principle, the political side, and especially legislatures just being the final arbiters of their own decision? Because that, I think, really plays through the entire stream of your book.
No, I think that's exactly right. One of the things that I realized doing this research was the stakes for a single seat in a legislature usually are not that high. Yes, the constituents want their candidate to win, but in the House of Representatives, 435 members, unless the chamber is so divided that one seat's going to make a difference, that the House itself can resolve it without political instability. There have been a couple of episodes that are discussed in the book where a single seat or a couple of seats in the House might determine partisan control, and those disputes can get a little ugly for that reason. But for the most part, having the chamber be the judge of its own elections has served the country adequately. For example, the so-called Bloody Eighth, thank goodness there was no bloodshed back in Indiana in the 1980s. One party really felt like it was robbed of a victory by the other party, so they can lead to bad feelings, but it doesn't lead to huge political instability. The young country didn't know how to handle disputes over chief executive elections, whether it was a governor's election at the state level or a presidential election at the national level. These were new things, and they hadn't thought it through. They just they had a lot to think about, and they just hadn't foreseen how to handle a dispute over a major chief executive. I mean, the king wasn't elected, and colonial governors weren't elected, and so an elected chief executive was a new thing. And so what's the institution to do that? Should it be the legislature? Separation of powers doesn't really want the legislature to control the outcome of that. Should it be the courts? They hadn't really set up judicial processes for that. So in this New York example, the legislature invented this unique tribunal, but it wasn't balanced. And coming back to this discussion that we've had over the years, there was in the legal world, there's a famous early American judge and legal scholar named James Kent from the state of New York, revered where I went to law school in New York. And James Kent was a young lawyer involved in this dispute on John Jay's side, as it were. And he writes a letter to his brother in the midst of the dispute saying, we need an equally biased tribunal. That's the phrase he used. Because he sees the tribunal as biased in favor of the other party, the Jeffersonian party, not the Federalist Party. And he thinks it's very unfair, but he doesn't have the words to talk about impartiality or neutrality, but he's groping for that concept and saying, we want something that's equally biased. So right there at the beginning of our country, we don't have the answer yet, but it's like, what's supposed to be the method that's perceived by both sides that really want to win, that think they have a legitimate claim? What's the right method to resolve this? Is it to be resolved by a fair tribunal or through some other procedure?
So Ned, just leading up to that, with the need for a neutral, sort of arbiter, we go to the 1876 presidential election, Hayes versus Tilden, which is the most disputed presidential election to date. And, we went to the edge of the constitutional cliff. The results weren't until literally the swearing in of the next president. What happened there? And, talk about some of the research into that race and why it's relevant today.
Yes, and that is, I think, the big one. The big one. Right. If there's any disputed election that I think we should teach in school so that all Americans sort of understand the history, I would vote for that one. And it does involve, among many other themes, the question of what's the tribunal. Because again, is Congress supposed to be the institution to settle a dispute? Just to set the stage, many of you may know this already, but this is in the aftermath of the Civil War during Reconstruction. Reconstruction is the folks who were in favor of Reconstruction and civil rights and the Republican Party at the time, President Grant, ending his second term, has wanted to vindicate the 14th Amendment, the 15th Amendment, voting rights and civil rights. But that is losing, frankly, to the forces of so-called redemption. The Democratic Party, particularly in the South, wants to undo Reconstruction and gain back local control. And there's warning signs that something cataclysmic might happen 4 years earlier in 1872, discussed in the book. We don't need to get into the details now, but some ugliness, a lot of ugliness in 1872. So things are very fraught. And Rutherford Hayes is the candidate for the Republican Party. Samuel Tilden from New York, governor of New York, candidate for the Democrats. And the dispute is primarily over the three southern states, because Republicans still control the apparatus of government, including the canvassing boards that are going to count the ballots, but Democrats are gaining in strength, including gaining in strength by really ugly intimidation tactics, voter suppression tactics in South Carolina, Louisiana, and Florida. If Hayes gets all of those states' electoral votes, he ekes out a bare majority of electoral votes. Tilden just needs one electoral vote from any of these disputed states to get a majority. And to make a very long story relatively shorter, the dispute ends up in Congress because competing slates of electoral votes get sent from these contested states. And Congress is divided. It's one thing for the House to decide its own elections, because it's one chamber deciding itself, or the same thing on the Senate. But when you have bicameralism and partisanship, you could have deadlock, and that's what happened. The Republicans control the Senate, the Democrats control the South. They couldn't control the House, sorry. And so what's going to be the resolution? We need a new president by Inauguration Day. So they create a commission. They try to adopt the neutral tribunal model, but they send up a very complicated version of it. They have 15 members of a special commission, very balanced. There are 5 senators, 5 members of the House, 5 Supreme Court justices. There are going to be 7 Republicans, 7 Democrats, and one of the justices is supposed to be a neutral. And they know who it's going to be through the mechanism that they set up, and he refuses to serve. And so they're left the way they structured the law, they need another Supreme Court justice, but there isn't anyone perceived as neutral. So they add an extra Republican to the 15-member panel, and so every decision that this 15-member board makes over Florida first, and then Louisiana, and then South Carolina, it's all 8-7. And so it's perceived by the other side as just bias, partisanship. And there's more to the story, but it shows an attempt to create a fair tribunal, but the implementation didn't work.
So this is a very rich book with it's not comprehensive. There have been many disputes and others, but it is thorough, and there are many instances that are very interesting. But we're going to skip through many of them from 1876 up to 2000, which is in the memory of at least some of the people in this room and some of our listeners, not too long ago, and important. So. Bring us into 2000, where some of these issues and the memories of 1876, or people reminding themselves of that, are part of that story. What's the summary and the big takeaway of the 2000 election in Bush v. Gore?
So, again, that was a genuine dispute. It really was a jump ball, given how close Florida was, and the fact that whoever got Florida would win the Electoral College. There's things discussed in the book, like people may remember the term butterfly ballot, which was pretty much outcome determinative, but not in a way that the courts could handle. We could get into the technical details. Some things courts can fix in litigation afterwards, and some things they can't. And the problems over the butterfly ballot just were not susceptible to being fixed. Arguably, the so-called hanging chads, which was another problem, was susceptible to a judicial dispute. There's a story to be told about the tactics that Al Gore, the Democratic candidate that year, used. I think with hindsight, if they had litigated differently, they could have put themselves in a better posture. I think ultimately the outcome would have been the same. I think no matter which way you move the pieces on the chessboard, in the end, George Bush is going to end up being president. So for any of those people out there who think the Democrats were robbed, I really don't think that's true. I also think the U.S. Supreme Court has gotten some unfair criticism for how it handled the case. Again, there are reasonable positions to have on both sides of the equal protection issue about how to treat these so-called hanging chads, which if people don't remember, didn't live through it. These are these odd, there's a kind of paper ballot that had these little particles that would be dislodged when you used a punch card. And the question was how they were going to be treated. And the principle that the Supreme Court adopted, if you're not caught up in the dispute at the minute, is a pretty fair principle. The principle is that all ballots that look alike in terms of the degree to which they've been punctured should be treated the same. And if some of these ballots in one part of Florida in a statewide election are being treated than the exact same ballot in another part of Florida, that's a problem. They then, more controversially, didn't remand. The dissenters wanted the state of Florida to have another chance to fix the issue, and the majority said, no, time's up. We've met the deadline, can't do it. But my take on this is that in a dispute of this nature, where there's reasonable positions on both sides, you do need a tribunal. Maybe, again, you could have constructed a fair tribunal with one Republican, one Democrat, and one neutral. Hard to do in the midst of a heated election like Hayes-Tilden chose as in 1876, unless you've set it up well in advance with contingency plans. And so if you need a tribunal, a judicial tribunal is going to be better than an ostensibly partisan tribunal. Maybe judges are going to be affected, but they're going to try to settle these things pursuant to the rule of law. And so my hope had been that whether you like that decision or not, the basic principle that this is going to be governed by law, by constitutional values like equal protection, would actually be a good thing for the country going forward.
And just to follow up on a little bit of that, because I know Don is going to take us into 2020, but two things. One, you are probably a little more favorable towards Bush v. Gore than some election law scholars. But you do note, I think all of us note, the significant rise in election law litigation since Bush v. Gore. I don't know if you want to speak to that, but is that, many of us got interested in elections because of Bush v. Gore, but also avenues were opened up. Bush v. Gore perhaps opened up some avenues. What's your thought about the follow-on to Bush v. Gore?
Yeah, so I think, again, I learned a whole lot by working on this book, to be honest. And one of the things I learned is that there was an effort, there was a dispute in 1899 over a very ugly election in Kentucky that went to the US Supreme Court, where the so-called great dissenter, John Marshall Harlan, who dissented in Plessy versus Ferguson and gets vindicated in Brown versus Board of Education, he writes an incredibly eloquent dissent saying that when there is unfair manipulation of the partisan manipulation of the votes to deprive the citizens of the true count, of the valid result, that should be seen as a 14th Amendment violation, because the whole point of the 14th Amendment was to bring into federal law vindications of fundamental liberties, fundamental rights, fair process, due process, equal protection, these things. And so to have an election stolen by political manipulators ignoring the truth, he said that should be unconstitutional. And like his dissent in Plessy versus Ferguson, he's the only dissenter. For most of the 20th century, the rule is the other way, that these disputes over ballots just is not a federal issue. And Lyndon Johnson has an important race in 1948 that where the US Supreme Court again says, we're not touching this, we don't touch these things. The Supreme Court's invocation of equal protection in Bush versus Gore is a vindication of John Marshall Harlan's dissent in this case, Taylor versus Beckham, because it's essentially the same principle. Yes, the 14th Amendment will protect the sanctity of true results, as the US Supreme Court thought that the Florida judicial system was trying to manipulate the process unfairly. How does this change come about? Because it's a complete 180 reversal from 1900 to 2000 over the course of the century. And the reversal is caused intermittently in steps because you don't get constitutionalization of voting rights at all until the Warren Court in the 1960s creates the one person, one vote principle in redistricting law, and then uses the one person, one vote principle to say there can't be poll taxes in Virginia, for example. And so we get some constitutional rights with respect to voting in the 1960s, but they're never used in the context of counting votes until later on. It first happens at the lower court level in an important case from Alabama in the 1990s, which we could talk about, in a case in Rhode Island in the 1970s, another important one. But Bush versus Gore is the first time that the Warren Court jurisprudence about equal voting rights gets utilized in the context of counting votes.
And so two more quick follow-ups before Don. So one, just to note the 1899 election that Ned referred to, and he referred to the higher legal principles behind it, just maybe from a more voyeuristic look at this. This is the terrible election, the only time we've had a sitting or a governor assassinated, and it essentially was a kind of war of two gangs. So this is not a pretty sight, even though we're talking about the legal principle coming out of it. But coming back to 2000, following on, I'm leading into Don's question about 2020, there's you mentioned a lot of the developments, and there are a lot of specific stories. There happens to be one story, a good story, about the 2013 recount in a very close race in an attorney general race in Virginia. And I happen to note that my colleague here, co-host, Don Palmer was the election director in Virginia at that time. So you're part of the good part of the story, Don. Can you just tell us a little bit, either something about that, and Don, if you want to weigh in, but also just some of the quick developments between 2000 and 2020 before Don moves us into that?
Well, I don't mention Don by name, I'm sorry, but I do cite that example as job well done. Virginia, frankly, it's not the only instance in which Virginia has done particularly well in handling some very close very divisive races, attorney general's races, for example, but some state legislative races that were where the control of the chamber really hung on the balance. So I do think if Virginia has a secret to be told about how to do this right, it should share it with the rest of the country. The one thing I commented on in the book, and I wish this could be replicated, because Twitter hadn't really developed very much by 2013, and Twitter was used in a very positive way at the time by giving transparency. There were tweets, all over saying, "Oh, we've counted." This is during the canvassing of the return, sort of updated verification of the results and technical corrections where it needed to be corrections, and that transparency, I think, led to a sense of, this is on the up and up. Nothing's been done by sleight of hand. There weren't any conspiracy theories running around Twitter about things gone wrong. And so I wish Twitter could be used for good as opposed to ill. That was something I noticed about it. But I'd be curious, Don, what your sense of it.
No, I thank you, Ned. I think that one of the important things was the transparency. And you did have informal through Twitter at the time. But during that canvassing period, when there were changes, and that is when changes in ballot totals take place, as long as that's a transparent, ongoing process, the parties and the campaigns weren't upset. They could see what was happening. They could confirm that there was an error or something at the local level. So I think transparency, real time, is really important because everyone's observing the election. Before we move on to the next question, though, I just want to say, after the 2000 election, you talked about rule of law and fairness, and you also mentioned the accuracy of the results was a real issue leading up to that. And so I think with the Help America Vote Act, we've had dramatic increase in the accuracy of elections. Where do you think we are on the rule of law and sort of those issues that you point out? Has the Help America Vote Act in 2000, after the 2000 election, has it reached its potential, or what do we still need to do?
Yeah, no, I think we are improving things. I think provisional ballots are hugely important, and I think to some extent we haven't fully utilized or fully brought into the consciousness just how important it is to have that safety valve. The book talks about a triangle of important qualities to any system to handle these incredibly intense disputes. The first leg of the triangle is good rules, good laws, because you can avoid disputes if your laws are clear and your administration processes are good, your machines are good. So you want to avoid disputes at the front end as much as you can. And I think we have made tremendous progress, both, frankly, in the 20th century, we did better in the 19th century, and even since 2000 with the Help America Vote Act and changes at the local level. The reason why you need institutions is laws that can never be clairvoyant and perfect in advance. So if a genuine dispute arises, somebody's going to have to settle it. So institutions are your second leg of the triangle, if you will. The third is humans, human virtue, human character. At some point in an intense dispute, you need good people, people of goodwill, good faith, trying to do the right thing. If your rules don't handle it and if your institutions aren't well designed. So as a society, we need to constantly try to make progress on all three of these dimensions: rules, institutions, and virtue.
And I keep promising Don's going to talk about 2020. I have one last interjection. I do note joining us in the room has been Don's colleague on the EAC, Commissioner Tom Hicks, but also Cameron Quinn, who was the predecessor running elections in Virginia. So we do have some wealth of knowledge in the room here. Second, I want to give a quick shout out on the Twitter point of 2013 to David Wasserman of the Cook Political Report. Many of you know him today with his election analysis. He really was the one behind that. And then finally, let's turn it over to Don. I had a third point, but I'm gonna move on to 2020.
Well, we have a new section of the book. It's called On the 2020 Election. And, reading it, it's a very detailed accounting of the drama that occurred with potential elector slates, what's going on in the Senate, what's going on with different groups of senators, and in each individual states. What was important about that election from your perspective in adding it to the book?
Yeah, Well, it really changes I mean, all the other chapters in a sense are still the same because the facts about 1876 haven't changed, or the facts about 1792, but my perspective on the totality of American history has changed. Regrettably, less optimistic. Yeah, I talked about how I was optimistic that the rule of law going in throughout this coming century would be a vehicle for doing a better job. And I thought Bush versus Gore, for all its wrinkles, might be a harbinger of that. But 2020 was something that we had never seen in any of these disputes, because, from my perspective, and I try to be nonpartisan and try to understand it as a scholar, what's really going on, this was the first dispute where there wasn't really anything genuine to fight about over the result. You could complain about the change of the rules prior to the casting of ballots because of the response to COVID. That's a different story, but those rules were settled. Voters cast ballots pursuant to those rules, and even if you didn't like those rules, there was no doubt which candidate had won the relevant states to make an electoral college majority. So the denial of the reality of the result was something that I had never seen in any of the history that I had researched. And John talked about how there's many episodes that we haven't talked about. The first draft of the first edition was 50% longer than what it was, and the publisher and editor said, no, you've got to cut this down to reasonable size, make some editorial judgments about it. So I tried to be as thorough as I could in studying this topic, but all the previous disputes were genuine in that sense. And the 2020 dispute was not genuine. It was not based on reality. The incumbent President Trump, his own attorney general told him that, his own campaign advisors told him that. I think, again, if we're focusing on the truth of the matter, we have to acknowledge that. And so to me, what 2020 shows is it's a confluence of two traits in American history that have never been brought together before. One is fighting over elections, which are important and people want to win. That's what this book is all about. But the other trait is what a prominent historian named Richard Hofstadter called the paranoid style of American politics. He wrote a book with that title after the Red Scare, McCarthyism in the 1950s. And the way he explained that difficult period of American history was that it was a recurrence of this so-called paranoid style, which started with the Salem witch trials, went through the Know Nothing movement and the anti-immigration movement of the 19th century. And so there's been these episodes of American history where the political culture becomes engulfed in a kind of mass, whether it's hysteria or whatever you want to call it. It's just a flight from grounded reality. And it happened over, Joe McCarthy said there are communists in the State Department, waving a list of the names of communists that he said in the State Department. It wasn't true. He was a demagogue, and he had fabricated this, but he was charismatic, and the country became engulfed for 4 years in McCarthyism until it ended. And when Rudy Giuliani was saying, here are the names of the fake voters in Pennsylvania, it was Joe McCarthy all over again, not having any basis in reality. But Giuliani was a charismatic figure from his political career. President Trump, obviously a charismatic figure, as we know. And so I've evaluated what happened in 2020 as electoral McCarthyism. It was this paranoid style applied to the voting process, and that's never happened before. And that's very dangerous, I think, for the conduct of democracy, because it's one thing to kind of get all out of touch with reality about whether they're communists in the State Department. That's not good. But to lose sight of reality over voting is self-government, government of the people, by the people, for the people. We have to be reality-based and grounded in the truth as we count ballots, as we do this. So, the good news perspective, if you want to call it that, with respect to this analogy to McCarthyism, is it only lasted 4 years. And so, we're sort of in the fourth year, arguably, with large number of American citizens not believing that the 2020 was valid because of this denialism. This fever may break because of how 2024 unfolds, and hopefully we'll cast votes properly and count them fairly and have a sense, oh yes, we can do this. We can run elections and accept the truth, whichever side wins. And if that's how this happens, then we'll look back on that difficult period as analogous to one of these paranoid moments that we thankfully was able to put in the past. That's sort of what I'm hoping will happen. If this flight from reality with respect to the voting process really takes hold and becomes a pervasive nature of American politics, I think we're really in trouble.
So I want to follow up especially about 2020 and some of the electoral college machinery, but first just to quickly return to the 2000 election and the follow-up. A couple regular listeners and those who don't know will maybe want to go back and look at a couple episodes we did. One with Doug Lewis on the passage of the Help America Vote Act, what was in the act, how it got done, which is a really quite interesting story, a bipartisan story. And second, another episode with Ron Turner, Supervisor of Elections in Sarasota, Florida, about on the ground, how the changes in what we've done in the Help America Vote Act have been implemented by local election officials and what things look like. But back to 2020, I think we were kind of electoral college geeks before 2020, but many Americans did not follow the inner workings of what happens after Election Day, the votes of the electors, and especially January 6th, the counting of the votes. So happy to have you say something about how the counting of the votes went on January 6th, but also maybe we can focus a little bit on the aftermath. In the aftermath of 2020, we have passed a new law, the Electoral Count Act, which attempts to put us on a better footing for January 6th and counting and fewer possibilities for disputes, clarification of things that were left unclear. So say something about the Electoral College machinery and something about this act and how you feel about it and whether that is going to serve us well in the future.
Yeah, I do think the reform that was a bipartisan reform led by Senators Collins and Manchin by the end of 2022 put in place this new law, which is a huge improvement over the previous law. The previous law had some really unfortunate ambiguities and convoluted nature of it. The book talks about how it took them a decade between 1876 and 1887 to come up with a law. They knew they needed a law, and it took Congress 10 years back then, and they knew it wasn't a great law, but they papered over some differences to have something instead of nothing, but they left that ambiguity to potentially be worrisome, and it did allow people like John Eastman, for example, to try to exploit the law for partisan advantage. And we have closed those loopholes. And to go back to this earlier discussion about should we try to design a good institution or should we try to get good rules, I think the philosophy of the Electoral Count Reform Act is, in the current polarized times that we live in, it can be very hard to identify who's a genuine neutral person that you would say we're going to entrust the resolution of a disputed presidential election to somebody who's neither a Democrat nor a Republican, but somebody who is everybody can trust. And so the first edition of the book was more optimistic that we could find that neutral tribunal. I still hope that we get to the point in our future where we can come back to that. But I think the value of the new statute that we have and the philosophy that we've adopted going into this year's election and for the foreseeable future is let's batten down the hatches as much as we can through laws that lack ambiguity and are really going to give us clear results that we have to follow pursuant to the rules.
So we are just days after the assassination attempt on former President Donald Trump. Now, you have new sections in the book on political violence. In fact, there's some discussion about the 1899 Kentucky gubernatorial race, which resulted in an assassination. Tell us about that section of the book and the history. Tell us about the history and the recent shooting.
Yeah, well, this is something that worried me writing the new edition over the last couple of years, and obviously worries me even more over the last couple of days. Again, the good news story from the perspective of 2015, when the first edition came out, was that it seemed like we had put violence over electoral disputes in our past. The 19th century has quite a number of episodes, unfortunately, with significant violence or threats of violence. And it's all over the country. It's Kentucky, it's Maine, it's Pennsylvania, it's Louisiana. So it's not a regional thing, it's not localized to any particular time within the 19th century. It happens in the 1830s, it happens in the 1870s, it happens in the 1890s. We can talk about why. There was conditions of extreme partisan polarization in the so-called Gilded Age in the 1880s and 1890s, which I think is why you saw violence in states like Maine and even a little bit of threat of it in Rhode Island and Kentucky, in Connecticut at the time. But the really incredible good news about the 20th century is that really disappeared. Starting with the progressive era, women's suffrage, I don't know whether that was a factor or not in just terms of changing the character of sort of who votes and who's involved in elections, but really starting in the 1910s through the 1940s, 60s, 80s, 90s, we still have these disputes that are talked about, but violence disappears. And no threat of violence in Bush versus Gore, despite how close that was. There were protests, but no risk of violence. And so the unknown question, you can just observe the facts. The facts is that between 2015 and now, there was January 6th, which clearly involved violence. There's the horrific assassination attempt 2 days ago. There's been the threats against election administrators that you know well about. And so the threat of political violence, actual political violence, has entered our culture in a way that it didn't exist for a century. And you have to go back into the 19th century to find equivalent versions of it. And so where are we in that regard? Is this a fleeting, terrible period that we can escape? Is it again associated with this electoral McCarthyism, so that if we can get rid of that paranoid style of politics, we can then get rid of the violence associated with it and get back to normality? I hope so. The risk is that it's more long-term than that. And if it is more long-term than that, we're potentially faced with a period of American history which we didn't have in our lifetimes before. It looks a lot more like the 19th century than the 20th century. It would be a form of backsliding, which I hope we don't have, but as a scholar, you have to raise that question and worry about that possibility.
I have one little follow-up before we turn to our final two questions for Ned, and that is, and I think I'm actually going to fill in some of the period you call peaceful with some violent episodes, but the question of violence against a presidential candidate rather than someone in office. And of course we have Bobby Kennedy in 1968. We also, I think many people forget, this is not a candidate exactly, but President-elect FDR, before he took office, there was a very serious attack on him, killing some of the people in the car with him just a month or so before he was going to take office. Is there something to be said about the issues relating to violence on the campaign trail or before someone takes office that you can highlight through some of your research?
Well, that's a fair point, and those episodes clearly are true. In 1968 was horrific with assassination of both Kennedy and King. The only thing I would say in addition to that, though, is, and obviously the assassination attempt two days ago wasn't involved vote counting. It was involving politics. This book focuses on counting votes and what happens when after the polls close and you're trying to count the votes and see what the result is. And we have had periods of political violence specifically with respect to that. Again, largely in the 19th century. The assassination in Kentucky was during the vote counting period. The bullet was fired from the Secretary of State's office, if you can believe it. And so that's, we didn't have disputed elections in the 20th century, not in the 1960s or the 30s, where fighting over the who won, we're going to get the swords or the guns or whatever in order to win this the way you saw in the 19th century. January 6th is violence as part of the contestation of who's going to hold office in the midst of a dispute over who's the legitimate winner. Again, I don't think there was a genuine dispute, but it was violence in the context of fighting over the result of the election. So I would sort of clarify and narrow my answer in that respect.
So we always end our podcast, and just to note, for those of you not listening to the podcast, watching it or watching it on C-SPAN, we're going to continue a bit beyond the podcast with some questions, but we always end the podcast with 2 questions. And Ned has been a guest on our show before. You can go back and listen to our Trump v. Anderson episode. So in a way, we don't want him to repeat ourselves. So we're going to adjust our questions a bit. So my question to you, usually we ask about how you got into elections, but I'm going to ask, how did you get into writing this book and researching this? There was an earlier edition, obviously, into this book about the history of disputed elections. And now that you know all you know, what would you tell your prior self? What was it that early Ned Foley didn't get about this that he learned throughout the project?
Well, I would tell myself, be prepared that it's going to take a long time to write a book that covers all of American history, even if it's just one slice of it, but starts at the founding and goes to the present. Because I actually started working on this book, believe it or not, in 2007. It was in the post-Bush versus Gore environment, and the goal was, it was not designed initially to be a history book, if you can believe it. It was designed to be a book about what are best practices with respect to recounts and contested elections. And so can we do a 50-state survey and figure out which state, like Virginia, does it the best, and replicate that and just have all the states use the best model. And what I quickly realized in 2007 was that methodology wasn't going to satisfy me in terms of finding an answer, because understanding how these disputes get handled, it isn't good enough just to know what are the rules listed in the statute books. You have to know how it actually plays out in the crucible of the context and the contestation. And that differs whether it's a high stakes race like president or a relatively low stakes race like a city council. So you can read a judicial opinion about what we should do to resolve the city council dispute, and it doesn't really give you the flavor if that same dispute would have happened with respect to a US Senate race or a governor's race. So I said, and the lawyer's method is to look for precedent that's most recent. You don't want to go back any further in time to find an older case if a newer case will settle the issue. But that's what drove me back all the way to 1792. I felt I really didn't understand this topic, and then didn't understand how the nation dealt with this topic without going all the way back to the beginning. And so it took a lot longer. And then relatively early on in working on the book, in 2008, some of you may remember Minnesota had a huge disputed election over a US Senate seat. This was Al Franken and Norm Coleman. And so I watched that dispute unfold as I was thinking about the larger point of the book, and almost took a detour to write a separate book about that, and said, no, it'll just end up being a chapter in this one. So that's what got me into this project, and it took a completely different turn in terms of methodology, but I would have told myself, be prepared for a long labor of love, because it's not going to be written very quickly.
So Ned, this is, you've obviously researched hundreds, if not thousands, of disputed elections. And again, you said you may read an opinion, you may get the historic record, but what's a funny or notable incident that you researched that you'd like to share of the disputed election, or some controversy in the book that we haven't been able to talk yet today?
Well, what's fun about the book, and thankfully people have told me this about the first edition, is it's written in a narrative style. It's not written, to be just dry analytics. So these are incredibly good stories. There's a lot of drama. in each of these episodes. You could make a good TV show or TV series about each of these things. And so I think you can read it on that level. So I won't go through all of them, but maybe to be optimistic and think about the better angels of our nature, so to speak. In the 1830s in Massachusetts, there was a gubernatorial election, and Edward Everett was the incumbent, and he's mostly famous for delivering an incredibly long-winded speech when the Gettysburg Address on the same day was crisp and short and the one committed to memory, whereas Everett's, 2-hour speech or whatever it was, is long been forgotten. But he did the right thing. So believe it or not, that was a gubernatorial election that was, believe it or not, settled by one vote. I mean, talk about every vote matters. One vote matters, and he did the right thing by saying, look, I think if you count the votes honestly, I didn't win, and so I'm not going to really fight for it. So to see an incumbent politician who wanted to hold power, he started trying to dispute it and said, no, I'm backing off. I'll let the truth prevail. I think it's a nice episode. And what's really kind of funny about it is he could have won the election if only his brother had voted for him, but his brother voted for the opposing candidate. And then even funnier, if that's not funnier, his own Secretary of State was part of his party, didn't bother to vote that day because he was out on the hustings trying to run the election or whatever he was doing. And so he could have won either if his brother had voted for him or if his own Secretary of State had voted for him. But maybe that was an omen that he wasn't going to win another term.
Ned Foley, thank you for joining us in the voting booth.
Thanks for having me.
Now we're not, as you know, we're not ending this event here. This is the first part, the podcast, which you'll hear in a few days, where you find your podcasts. You can listen to, but we have both live visitors with AEI stream, and again, to remind you some of the questions that could come in if you wanted to ask a question through the internet. It would be one to email jhunlee, jahun.lee@aei.org, or to use the hashtag AEI voting booth on Twitter X. So we're looking for your questions. We're looking also for questions in the room, and then the other thing I'm going to remind you is that Ned has been generous and will be able to sign some of his books after this for those people in the room. So I'm going to look for some questions. I might also have some questions online. And we'll go right here. And just one thing is if we could wait for the mic and then identify yourself. And of course, as they say, always ask a question, not a statement. Right here, the blue shirt.
Excuse me. Thank you for being here. My name's Collie. I'm an intern here at AEI this summer. I'm curious, these 21st century sort of election disputes have been very public, dominated national discourse in the media. I'm curious if prior disputes, going back to 1792, have dominated the national political discourse in the same way, or if these battles were taking place behind closed doors and sort of in courtrooms and in Congress.
Yeah, that's great question. I think they were. I mean, the media environment was obviously so different. No Twitter, no social media, and so forth. But the newspapers were full of coverage of this on a regular basis. And the press was very partisan at the time. So in some ways, I think it's encouraging in that, we worry about media siloization and the fact that there's Fox and MSNBC and that sort of thing. Well, that was happening in the 1790s also. Madison and Jefferson were using their press outlets to advance their partisan position, and the Federalists had theirs as well. And both sides were writing extensively about what was going on. Everybody, that was what was so interesting to me, was that this New York governor's election wasn't just covered in New York. James Monroe, Madison, Jefferson, other prominent Virginia people like Edmund Randolph, they were all over this, and because they knew it was an important event for the country as a whole.
Gary Schmidt. Mike?
Gary Schmidt, I'm a senior fellow here at AEI. And despite that title, I don't remember 1876. So I wanted to go back. By the way, the other little comment is it's unusual for a law professor to be able to write such great narrative, so congratulations. I want to go back to the Kent quote that you mentioned pretty early on about needing two biased entities to resolve something. And you mentioned that he just didn't have the vocabulary for something along a neutral, institutional line. I'm reminded that when Hamilton set up the sinking fund, he created basically kind of a neutral set of folks who could manage the sinking fund in such a way as that partisan viewpoints would get taken into account, but also just to give legitimacy to whatever activity they did in terms of the sinking fund. So that gets me back to the Kent quote. I'm wondering whether Kent actually had the vocabulary, but was more inclined to think that this is one of those issues where it's really not possible to finally have a neutral arbiter. In other words, he's not pointing towards neutrality. He's actually reflecting the fact that these kinds of judgments ultimately come down to be political. And political in a broad sense, political in high sense, political in the low sense, but nevertheless, it's a judgment call, not something scientific, as you would expect from a fact-finding effort.
Yeah, I think that's a fair and important question. I guess I would interpret it. Hamilton himself clearly believed that the proper way to handle these things was political. John Jay was willing to really go to the mat on this, and by going to the mat, again, there was sort of militias forming, and they thought about. They knew how to do revolution, and so they thought about going into constitutional convention in the state of New York to repudiate what the lawful resolution of the dispute would be against them by saying we're going to take matters into our own hands at the level of popular sovereignty. And Hamilton said, no, that's very dangerous. If our side does that, the other side could do that down the road. You're playing with fire. The better thing, and he wrote a letter to John to say, just graciously concede defeat, even though you were robbed and you thought, and just run for re-election the next time and beat your opponent the next time. That's what happened. So Jay ultimately said, I'm not going to fight this, and he did win the election. And so that view has existed throughout American history. That was sort of the approach that Richard Nixon took, I think, in 1960, when he had a plausible claim that he had been robbed in Illinois and Texas. Very debatable, but there was some plausibility to that, more so than I had imagined before writing the book. The other view, which actually was Madison's view in various disputes that he was involved in, is no. As a lawyer, we need to. There is a legal answer to this. We're used to courts that can handle evidence versus rules of evidence, and so we want the right answer. And my reading of Kent is he's more, even though he was in the opposite political party of Madison, he was more in that mindset. He wanted the rule of law to answer this, and he didn't want political partisanship to do so. And I don't know why he said what he said the way that he said it. It is true that we've struggled in this respect, and the Hayes-Tilden example was where an attempt to create a neutral tribunal didn't work. But there are episodes discussed in the book where the neutral institution did work. Minnesota, again, has done this quite successfully twice, where modeled on labor management arbitration, they create 3-member tribunals where one side has one representative, the other side has their representative, and the two of them pick some third representative as in case you need a tiebreaker. And Minnesota used that in 1962 for a gubernatorial election, and they did a version of that for the Frank and Coleman election. And both times, those 3-judge panels ended up being unanimous because they were sort of wanting to be on good behavior. They had not sit together before. They wanted to do the right thing. And that did create an air of legitimacy. Well, if all 3 judges two from each side and one neutral all agree as to what the facts are and what the law requires, that's sort of the best way to handle this. So Senator Pell recommended for a disputed Senate seat in the 1970s, that creating that and looking to arbitration as a model. So there's been some attempt in American history to try to do this. Kent just didn't flesh it out back in the beginning.
Question right here.
I'm Amelia Lamont, and I was wondering if you thought that, once the 2024 presidential election has happened, if you think that something like 2020, what happened in 2020 after the election, could happen again, like either way that the election goes?
Yeah, I do, unfortunately. I mean, again, I think the good news with this Electoral Count Reform Act means that some of what happened in 2020 just can't repeat itself. So that's important. The thing, and again, I don't want to envision horrible things that happen that hopefully won't happen, but the most important thing I think to say about 2020 in relationship to 2024 is the human virtue piece of this, in the following sense. Let's assume there is contestation this November and December over counting votes in battleground states, and both sides think they've won some states, like, could be like Florida 2000 or 1876 or 1960 or whatever. And so under the legal regime that we now have in place, that's supposed to be handled primarily in state courts pursuant to state law. If there are genuine federal issues, it goes to federal court. And the new statute says whatever the courts decide Congress is promised to accept the judicial resolution of these fights. So that should work well, assuming Congress follows its own pledge. But there probably isn't any mechanism in American law to force Congress to obey its own pledge. So we have to trust that members of Congress are ultimately going to follow their own rules. And so I want to presume that they will, but that's contingent on their behavior.
We have a question here, and that probably is going to be our last question for now. Sorry.
That gentleman's had a hand up for a while,
sorry.
too.
We'll go here, and then all right, we'll do two more questions. Yep, sure. Mm-hmm.
JP Hogan. 2020, did you study with the early vote? You mentioned the COVID rules. They allowed early voting. Did you study if most of the election had been decided and voted on election day, would Trump have won? Because it seemed the Democrats got their votes in before he did most of his spending to correct the lying they were doing. So it's with the ballots, did you make a determination on election day versus weeks earlier when the Democrats were using their machine to get the early votes in before he spent against what they were running against him?
Yes, I think if I understand the question, I think I'll say two things about that. First of all, I think you can look at a lot of elections in American history where if the rules for running the election in advance had been different, the outcome might have been different. I mean, the elections where we've had a disconnect between the so-called national popular vote versus the Electoral College is a clear example that two different kinds of rules produce two different results in the outcome. As a lawyer, I strongly believe you have to play the game according to the rules of the game set up in advance. So I might not be a fan of the Electoral College, but if it's our system, that's our legitimate system, and you can't complain that you would have won if the rules had been something different. So I guess that's one point. If the question is specifically about the changing dynamic of vote counting that definitely occurred in 2020, that's something I've written about a lot, not just for this book, but in some of my other scholarship, but definitely talk about it in the new chapter here, because of some of the rules that adopted in the Help America Vote Act, but more particularly because of the rise of so-called no excuse absentee voting. I mean, prior to the 21st century, we used absentee voting very rarely as a percentage of ballots for people who were away on business or hospitalized or what have you, and you had to have an excuse. But starting in California and some of the western states, they expanded that. And what I started to observe in 2012 was that expanding this opportunity of a new, more convenient way to vote was causing what I called the blue shift in electoral turns. That what would happen is that election night totals, as reported by the media, would tend to be more favorable to Republican candidates, but that as valid votes would be counted during the canvassing period, they would tend to shift more favorably to the Democrats. And you could see this in 2008, you could see this in 2020, and this was a new phenomenon of the 21st century as a result of changing the voting rules. They were still valid votes, they were all valid votes, but they were be counted later on, and it was partly because, as we learned in 2020, states like Pennsylvania, and at the time, Michigan, that expanded their use of absentee balloting didn't change their counting rules. Other states like Florida, maybe Virginia, Ohio certainly, were able to modernize their counting of absentee ballots as they expanded to no excuse absentee ballots. So what happened in 2020 was, and this was predictable, I explained how this was likely to happen in a law review article that I wrote in 2019, was that on election night, Trump was likely to be ahead in a number of these states. It was also called the red mirage by the media, if you remember that term. But those leads would disappear as additional valid votes were counted. And based on Trump's own reaction to a similar blue shift that occurred in the Florida elections in 2018, this was when Governor DeSantis won his governor's seat for the first time, and Senator Rick Scott won his senator seat. The blue shift was happening in a way that was very predictable to me, having done the work that I'd done back in 2012 and research, but was a very nerve-wracking phenomenon to the media and to politicians for whom this was a new thing. And Trump was exploiting this on Twitter and saying, only count the votes that were counted on election night, stop counting votes. This is not something that can happen legitimately under the law. These are valid votes. And I was very worried that he would replicate that same response with respect to his own election in 2020, and in fact, he did, and set in motion, the contestation that lasted from election night all the way up through January 6th.
One last question as part of our formal program, and I know some of you have hands, so Ned will be here signing books, so maybe we'll get to talk about those other questions then, but the floor is yours.
Thank you so much. My name is Dr. Myrtle Alexander, currently a congressional candidate for Washington, D.C. So as we look at the history, and I'm finding this forum quite fascinating, looking at the 21st century and from 2020 to now with COVID and the ballot box itself, and with the recent implication of the Safeguard America Voter Eligibility Act, what can you say about what we should anticipate for this 2024 election when it comes to ineligible voters?
Yeah, the historical record is that we've had, very few ineligible voters voting in American elections. The percentages are very, very small, not non-existent, but almost always not affecting the outcome. I think the most interesting and relevant election to think for modern purposes is an election in Washington state for their governor in 2004. And that was an election where the two candidates were separated by about 120 or 127 vote margin statewide, so very, very tight. And it turned out through litigation, there were about 1,000 ballots that were genuinely disputed and actually shouldn't have been counted, but were counted. And once you count a ballot, you can't uncount it, and so it's mixed in the pot. But they were able to identify through the litigation what why those invalid ballots were counted. Only a handful were so-called deceased voters, and obviously anybody who's deceased can't cast a vote, but some votes were cast on behalf of deceased individuals. But again, I think that number was less than 10, if I remember, certainly less than 20. I don't recall any non-citizen voting in that election as a source of invalid votes. The largest segment of invalid votes were so-called felon voters. These were individuals who were disenfranchised by virtue of state law that is felon disenfranchisement, and yet had been allowed to register. There wasn't any fraud or even allegations of fraud. It was just sort of mistake. People didn't realize that they had lost their privileges and sloppy voter rolls and what have you. And so you had former felons who were listed as registered voters who cast ballots where they weren't eligible. That was the biggest segment. And the second biggest segment were provisional ballots that ended up being counted by local election administrators, but according to the valid rules, shouldn't have been counted. Those were in hundreds or so. So that's the most consequential election in recent American history where you could say ineligible ballots were outcome determinative. Otherwise, it's virtually non-existent.
Ned Foley, thank you for writing this book and this new edition, which again, I hope everyone will purchase for their loved ones, for themselves. Thank you for joining us today, and thank you for all your work.